SJC-12396, Commonwealth v. Angel Alvarez.
If you hurry, it's good morning.
Good morning, Chief Justice. May it please the court. David Rangaviz for Angel Alvarez. This case has 3 issues, and I want to note at the outset that I want to try to make sure to reach the closing argument issue because I actually believe that that's the strongest ground for reversal here, but I'm going to start with the vouching issue because that was the basis of the grant of direct appellate review. Allowing treating doctors to testify as experts is flatly inconsistent with the prohibition against implicit vouching. Both this court and the appeals court have repeatedly recognized that the risk of vouching is at its apex when the Commonwealth asks its witness to wear 2 hats, and when a doctor with a treatment relationship with the alleged victim also testifies as an expert in the field of sexual abuse.
So I guess the issue is because when you have somebody who's treating, as you point out in your brief and as we know, and they're going to be an expert, the jury is going to perhaps most likely, give more weight. They've decided to treat the person.
Exactly.
And they were there for the actual physical exam.
Exactly.
So the question is, should the rule be the same when it's a situation where the expert is on the witness stand talking about, for instance, without tying it to this particular situation and this particular alleged victim, well, these are some of the characteristics that you might see. A delayed disclosure, whatever it might be. But it's different when it's physical characteristics and you've got the treating physician there and said, well, you know, there was no evidence of tearing here, and then being asked as an expert, how does that fit in your usual child sexual abuse case?
Right.
Is there a difference? And if there is a difference, should there be a blanket rule anyway?
I don't think there is. I think the line you're drawing is between behavioral symptoms and physical symptoms.
Precisely.
And I don't think there's necessarily a difference. If the jury knows that the expert knows that this alleged victim has that trait, be it a behavioral symptom or a physical symptom. So there could perhaps be a difference if the expert testified, I only did a physical evaluation. I know nothing about the behavioral symptoms of this alleged victim. Then there could perhaps be a difference, I think, because then the jury's not drawing that implicit conclusion that the experts actually, even though purportedly talking about victims in general, is actually talking about this victim in particular. And implicit vouching, I think, is particularly problematic in this category of case because these cases so often turn on the credibility of the person who's being vouched for. And the person doing the vouching is a doctor to whom the jury is going to be particularly likely to defer. So I think this court should take the opportunity provided by this case to draw 2 clear lines. First, treating doctors can never testify as experts, I think, with the limitation that I just addressed in response to your question. And the second line being even independent experts, I don't think, should be able to testify to what's typical, common, or normal, what behavioral symptoms are or physical symptoms are.
But this isn't a behavioral case, right?
No, it's a physical.
It's just, the only issue we have is that she testified about absence of injury to the vagina, right, or something.
Yes.
And that's all she talked about, right?
And then she was asked the question of is it common or is it not common? And this is something that I think is unique to this case. And this court wouldn't need to go as far as I just addressed.
And can I just load it one fact further for you?
Sure.
It's 3 years old, right? How old is...
It's not 3 years old at the time of the evaluation. The time of the evaluation is right around the time of the first complaint.
Okay, so the evaluation is right after, but is the first complaint contemporaneous with an alleged sexual assault or not?
No, there is a delay.
So bear with me. What is the delay that we're dealing with here?
Your Honor, I'm not exactly sure because the indictments are diverse dates.
But I thought it's years, right?
Yes, 3 years, and the indictments are diverse dates starting from the alleged victim's 6th birthday to 9th birthday. Yes. Because she's between 6 and 9, she doesn't exactly testify when precisely everything is happening to her. There's the one incident in the bedroom that she says happens when she's 6. There's the incidents with the taxis where I believe she said that they happened when she was 7. And then the first complaint happens when she's 9. And then there's other alleged incidents involving the sleepover episodes, which I don't think there's a date limitation on when those are happening. So there is certainly a delay.
The time between the last alleged assault and the physical examination is how long?
I just don't think there was ever testimony about when the last assault was. It was just that it happened over the years of her being 6 and 9, and then then the physical evaluation is very shortly after the first complaint. But I don't think there's any testimony precisely because of her age and her having issues with the trial being, I think, 3 years after the last incident. And so that was why there's not a degree of precision, and we don't know exactly when that happened. But there are case-specific reasons why I would urge the court to find this to be reversible error here. The main one being the judge sustained the defendant's objection. The question was asked, how common is physical injury? There's an immediate objection, and then the expert testifies, it's very uncommon. And then they go and they have a sidebar conference, and the trial judge rules, in my view, asking her to comment on how frequently there are physical findings in the context of a sexual assault case does stray too close to the credibility component of the case. That's volume 3, page 56. So the judge exercised his discretion in the defendant's favor, and there was a motion to strike by the defense, but it was erroneously denied. So
Was that the one where Judge Wren didn't hear it?
that's the one where Judge Wren didn't hear it.
Okay.
He didn't hear the answer that's
Right.
reflected in the transcript of it being very uncommon.
But in that case, wasn't there additional information in the closing, the defense basically agreed with the doctor and said just because there's no evidence of it doesn't mean it didn't happen. So is that actually prejudicial, I guess?
It is prejudicial, and this is I think the key point about, and I would point you to the Deloney case from the appeals court. I think is particularly helpful, and I cited it in my brief. I think there's a significant difference, and Deloney bears this out, between testimony saying that most true victims have X trait, and then that would be the major premise, and the minor premise being this alleged victim has X trait. And the conclusion that's implicit in that is this alleged victim is a true victim. But of course, it's perfectly appropriate for an independent expert to testify that just because there's no physical injury, it doesn't mean it didn't happen. But when you stray into having testimony about what's typical, what's common, what's normal, then what you're really saying is that because other cases have this attribute, this case has this attribute, and therefore this case is more likely to be a true instance of abuse.
Even when we're talking about sort of a fairly standard expert view that you're not going to have injury in this context, right? I mean, especially when it's not immediately after. I just don't know if this is, I understand your point in the bigger picture, but this case, the expert testimony seems to relate to something that there's not much dispute over and not that controversial.
Well, there was actually a lot of dispute. The main dispute being
Dispute over whether you're going to have injury to the vagina. I mean, she testifies that your vagina is going to be like your mouth, right? And it's going to it's recoverable.
it has healing properties.
Right. And that's not controversial, is it?
No, that's not controversial. There's a few areas that the defense
But it's not like we're
has disputed.
describing some bizarre set of characteristics. We're describing some kind of standard medical.
No, it's been disputed from the trial level and to now on 2 prongs. One being treating doctors just shouldn't be allowed to testify as experts. And 2, there shouldn't be testimony, and this is the judge's ruling.
I get your bigger argument. It's just I'm trying to focus on what her expert interpretation was.
Her expert testimony was that physical injury is very uncommon. That's on volume 3, page 55. And this is the judge's ruling, that the experts should not be allowed to testify about what's typical or what's common. It strays too close to the credibility component of the case. So Justice Budd, Justice Kafker, I totally agree with you that it's appropriate for an independent expert to testify that just because there's no injury, it doesn't mean it didn't happen. That's exactly what an independent expert should testify to, because that's the distinction that this court drew in the Dockham case, which is the first case that allowed this. It's the difference between allowing the Commonwealth to use this as a shield and a sword. And the whole point of this, going back to Dockham, which is that first case, was to cure inaccurate assumptions that jurors might hold. And I made this point in my brief, and it's made at length in the Deloney opinion from the appeals court. But it's a totally different thing to then allow this narrow exception for curing potentially prejudicial beliefs held by potential jurors, to then repurpose it and have it actually be allowed to be used by the Commonwealth to prove that an assault happened here. That's not what this is supposed to be about. So I think this court should make those clear.
We're going to have to reverse Commonwealth versus Quinn then?
Quinn?
Quinn.
Oh, Quinn. No, Your Honor, I think Quinn is similar to this. And what's unique about this case is that there's actually...
But you're saying that we need a black and white rule. We need a rule that says expert can't testify in a case in which they're the examiner, right?
Yes, it's
Unless they're a fact witness.
Unless they're a fact witness. I mean, it's a unique part of this case that this court actually said in Federico that this practice has been disallowed, but then I don't, if the law changes but the practice doesn't change, it doesn't matter. But
I mean,
no, I am advocating a change.
Yeah,
that was the basis of my request for direct appellate review, was asking for a blanket prohibition, because it's happening over and over again. Justice Smith tried to clarify this in the Rather opinion and tried to kind of lay out some guidelines for what the Commonwealth should do to make sure there's no prejudice, and it's just not happening.
Right, same thing with the drug cases, especially in the district court, where you have the arresting officer being the expert, and there's the concern with the vouching, and then in response, well, it's expensive and not that easy to get another expert, and we sort of see that in this case as well, because the prosecutor is saying, well, it's not that easy to find one of these experts. So since it is direct appellate review on this issue, you've got on the one hand what I think is a very legitimate concern, that the doctor has this enhanced credibility because they're involved with the child.
Right.
On the other hand, a lot of issues with child rape are completely counterintuitive to the jury.
Right.
And there may be an interest in the executive branch having an expert, but there's a limited amount of experts out there. And so we're trying to figure out, based on your brief, whether or not to have that blanket rule.
Right, and I don't think, defendants should have a slightly less fair trial because of logistical concerns, but there are ways to fix those logistical concerns. Irana is a good example of a case where there was a stipulation, and here there could easily be a stipulation to the fact that there's no physical injury, and then you could do what was similar to the Hudson case, which would be the treating doctor testifying as an expert, but making no mention of the fact that they're the treating doctor and that they treated this alleged victim. So there are ways to kind of get around some of these logistical issues. But
is your rule prospective?
I'm sorry?
Is your rule prospective? So your client doesn't benefit from that rule?
No, Your Honor, I think he should benefit from the rule. I mean, he's been advocating for the rule.
So we're changing the rule, but your client's going to get, I have to reread those prospective versus retroactive cases every time. But so
Right.
If we change this rule, we reverse your client's case because we apply it to him.
Yes, because he's been advocating for this rule from the motion and limine phase, and we could even set aside whatever the court does prospectively about that rule and just look at this case. The judge ruled in the defendant's favor on the propriety of this testimony. He just failed to strike it.
Although he allows the testimony in later, or she allows it in.
He allows it in later, but the part he allows in later is the perfectly appropriate part about just because there's no physical injury doesn't mean it didn't happen. But Judge Wren rules that any testimony about what's typical or what's common, it shouldn't be permitted and it shouldn't come in. The only reason he didn't strike it is because he didn't hear it. And then what's even worse is that then the prosecutor comes back to this as the final question on redirect and says, how typical is physical injury on victims of abuse? And there's a timely sustained objection, but the jury's left to fill in the blank with the earlier unstricken answer that physical injury is very uncommon.
Can I just, go ahead, finish your
And the
thought.
prosecutor argued the vouching inference in closing. That's the final thing I would
I
say.
actually wanted to get to the closing.
Yeah, I wanted him to be able to get on to his next issue.
And
Yes.
So There's no objection to the closing, and you have what seems to me a really serious problem with the prosecutor's closing about when the prosecutor says something like, well, in a lot of these cases, of bringing in a whole bunch of other cases, nothing
Yes.
to do with the evidence. So
Yeah.
I guess I'm sort of asking you where the substantial risk against, in this case, with what seems like really improper argument.
Well, I think the most improper argument was the part that was objected to, which is the inclusion of non-existent evidence about what the first complaint mother's testimony was. And then if you look to Kozik, you can actually look at the other errors I'm alleging in the closing argument and consider them as to prejudice at that point, because we're already in the prejudicial error analysis at this point, because the Commonwealth is conceding that the evidence cited by the prosecutor about what the mother said about her coming home and wanting to take a bath and not actually taking a bath, and that she thought it was weird, that didn't exist. So then we go through the 4 prongs of the analysis. Was there an objection? Yes. Was there a curative instruction? No. And I collected all the cases in my brief in footnote 5, explaining how the standard instruction is not a curative instruction. Did it go to the heart of the case? Yes. The prosecutor said in opening and closing that credibility was the heart of the case. This case comes down to credibility. And might it have made a difference? Well, this is Beaudry. This is Miskina. The Commonwealth cannot cite non-existent evidence in a credibility case to bolster the credibility of their alleged victim. They just can't do it. So I would submit that the closing argument issue, it isn't close. It squarely hits all the 4 prongs of the prejudicial error analysis, and then you layer on top of that kind of the setting of, the way I think about it is like the setting of evidentiary expectations. Kind of, this is the normal case. This is how this works. This is, in a lot of these cases, this is what we see. So it's a problem. And then the third issue with the closing argument that I've alleged is, of course, the reference to the potential witnesses that actually didn't testify. So, whatever the court decides about, perspective, not perspective, I think this conviction has to be reversed. The closing argument issue, look at the prime placement it had in the prosecutor's closing. She said, there's 3 reasons why we know she's telling the truth. The first reason is a non-existent piece of evidence that wasn't in the record.
But you have other corroboration, right? The prosecutor makes a mistake on the shower statement.
Right.
But you do have her coming home on New Year's Eve, that she didn't want to drive with her uncle in the taxi. So there's other corroboration, right?
Right, and the other corroboration has, and I explained this, I think, in footnote 6 of my brief, it has a kind of very obvious, apparent from the record, innocent explanation. She didn't want to drive in the taxi because he took her on some of the fair rides and she didn't want to be delayed in getting home. She went home after New Year's because she gets homesick and wanted to be with her family. I'm not saying it's kind of inelectable that the jury would have assigned those innocent explanations, but they're very clear from the record. And the Beaudry standard is really just, the quote from Beaudry is it at least plausible that this error might have made a difference? And I think it's much more than plausible in this case. Now, of course, there are those other, alleged corroboration, but there's a very clear innocent explanation for both. It's apparent in the trial record. If your honors watch the video of the interrogation, there's no dispute from Mr. Alvarez as to those 2 alleged incidents. So that's how I would address the closing argument issue. If there's no further questions, I would.
Just one more question, just about the Bowden instruction.
Sure.
Did you have anything to say about that? Because it seems like a concern is if you are allowed to argue about defense, but the instruction given by the judge sort of negates the defense, that's a problem for your client.
Yes.
Yes.
I don't have
That's
infinite
what she's-
time, so
that's the argument. Okay.
that certainly is my argument. I think
But everything the judge said is true.
everything the judge said is true.
To the
it's-
evidence.
And that's exactly the same in Smith. Smith is about a missing witness instruction, but it's the same problem, and it's also on a substantial risk analysis. And this exact same instruction, again, it's true, but it's given in Gilmore, it's given in Remador, and those are actually Bowden cases. Sorry? So it's actually kind of fairly clearly established from the jurisprudence. I think it's so clear that I cited in I think the final footnote of my brief, the Tolan new trial briefing written by the Commonwealth in that case, where they basically argued this exact same thing that I'm arguing. And Tolan was a case where there was this normatively appropriate instruction, but also a specific Bowdoin instruction. And in that situation, of course, kind of the general instruction doesn't negate the Bowdoin instruction. The Bowdoin instruction will be viewed as an exception to it. So I do think the Bowdoin issue is critically important because it was kind of a two-pronged theory on the part of the defense, and both were kind of things that the errors that happened infected. The first part being there's no corroboration. We have no corroboration of what she's saying, and the prosecutor's closing argument by adding an element of corroboration that wasn't in evidence kind of really harmed that part of the theory. And then the second part being the Bowdoin discussion in the closing argument that, why are you waiting 7 months to talk to the first complaint witness? But the judge instructs them, don't think about things not in the record, and of course it's a perfectly, I do not quibble with the fact, I think I said this in my brief, that it's a normatively appropriate instruction, but when you're making a Bowdoin argument, it really goes to the heart of it and it guts it. And those were the only two things the defendant had here, and they were both basically taken from him due to these errors. So I'd urge the court to reverse the conviction. If there are no further questions, I'll submit.
All right, thank you.
Thank you.
Good afternoon, Your Honors. Excuse me. I'm Nathaniel Bodwin for the Commonwealth.
No relation to
Okay.
Mr. Bowdoin.
Exactly, no relation at all. I first want to address a question that Justice Kafka had in the very beginning about the length of time between the disclosure and the last incident. The victim disclosed in January of 2014. She also testified that 1 month prior to the New Year's Eve incident, she slept over the defendant's home, and that was when also an incident of sexual assault occurred then. So what you have actually is only a time period of 2 months between the final incident of sexual assault and when she disclosed. And this victim also talked about the fact that her mother was undergoing surgery, and she wanted to delay disclosing what was happening with the defendant until her mother was feeling better.
But the New Year's Eve touching, was there a touching New Year's Eve?
No, there was no incident on New Year's Eve, but she testified that a month prior to New Year's Eve, she had slept over the defendant's house when the defendant's niece was there, and there was a sexual assault occurred on that occasion.
And the nature of that sexual assault was what?
Was a digital rape. And so
So the expert testimony we have is that so we've got a 2-month lag between the examination, at least a 2-month lag between the examination and the last sexual assault. And then we have an expert testifying that no signs of such assault are not, I can't remember, what is the exact terminology she uses?
that she had a normal examination, that there were no signs of physical trauma.
And what's her expert testimony on that point? Her expert testimony...
Was that she had a normal examination.
No, that's her testimony as a fact witness. What is her expert testimony about, that there won't be abrasions or whatever? What does she say there?
She describes that the female genital anatomy is similar to the tissue of the mouth, and that it has healing properties, that they heal very quickly. I believe she discusses the fact that when you bite the cheek of your mouth, you can tell that it heals very quickly, and you won't see any physical injury from that within a very short time frame.
But then your brother makes the point, the most objectionable statement she says is what? Is from his perspective.
Well, I think there was two things. One, when she stated it's very uncommon and it was not struck by the judge, and then then towards the end of her testimony, the prosecutor asked the expert, and do you have an opinion to a reasonable degree of medical certainty based on your background, training, and experience whether the absence of physical trauma is inconsistent with sexual abuse? And the expert's response was, the absence of physical trauma is not inconsistent with abuse.
And was that objected to? No.
That was not objected to, no.
So that's really what we're dealing with here. That's the expert testimony, that statement. That's it, right?
Yes. And I just want to state here that I think this case is an example of a prosecutor following all the rules and all the guidelines that have been established by case law. And it shows that those rules work. And those rules work because there wasn't any improper vouching on the part of the expert here. And no vouching occurred because you have to compare this case and the record here with all the other cases that have been cited by the defendant.
But doesn't it get more, I mean, I see the point here, but Deloney does a very good job of showing how it does get confusing, right? In other circumstances, when you start elaborating on behavioral characteristics, as Justice Lowey was talking about earlier, doesn't it get much harder to do this in other circumstances?
I think, yes, I think there's a very fine line here, and I think the judge was very clear that there was a fine line. He expressed that when he made his decision allowing this testimony. But I just want to suggest that there was no improper vouching here because this expert did not provide any complaint testimony, which is very different from the Swain case, the Trowbridge case, and the Velasquez case. This expert did not directly link this victim in this case to sexual abuse victims in general, and that occurred in quite a lot of the cases cited by the defendant, including Trowbridge, including Vasquez, including the Quinn case. And also, the judge specifically stated that this was an expert who examined the victim on one occasion on a referral from an emergency room. And for that reason, it's quite different from the cases, including Quinn and McCaffrey, where the expert was the victim's therapist. In Quinn, I believe the therapist had seen the victim for 8 months. They had 20 to 25 different sessions. In McCaffrey, the expert was the therapist. She had seen the victim for over a year. The expert testified that the victim told her that the defendant abused her. The expert testified that she put the victim in special group therapy sessions with other child abuse victims, and it was because of that testimony that there was improper vouching, that the jury could have inferred that this expert took on the victim as a patient because she believed the testimony, because she believed that the allegations were true. This is also not a case where the expert commented on the ultimate issue. You had the case of Colin C., where the expert actually opined, I believe that the victim was abused by the defendant. And there was also no comment whatsoever on the truthfulness of the victim's testimony, like you saw in Montanino, which was basically the expert there was expressly saying that the allegations were true, or in the McCaffrey case where there was sort of implicit testimony that the victim was being truthful.
And how did the witness describe her specialty? As a gynecologist or as?
Dr. Forkey said that she was the chief of the Child Protection Division at UMass Memorial Hospital, that she was board certified in pediatrics, that she had practiced in the area of child abuse pediatrics for 20 years. She said that she was a member of the Helfer Society, which is a society of physicians who specialized in treating abused and neglected children. And as the prosecutor pointed out, these experts are very rare. They're specially trained, and that they're limited in number. And I would also suggest this scenario is different than, I think, the police officer and the DRE cases. It's not, well, maybe you could argue that it's difficult to get another police officer to testify as a DRE, but I would suggest it's not as difficult as in these cases. I think it would be much easier for a police department to find someone besides the investigating officer to testify about the drugs.
Do we have a different situation if the testimony had been that a particular physical condition or whatever is consistent with being a sexual assault victim as opposed to being inconsistent?
I think the language is important, and this expert did not say anything about consistency.
Well,
She did not directly
She said it is not
link.
inconsistent, so she did speak about.
Well, there wasn't I guess what I was trying to say, there wasn't a direct link, and I think the cases make clear that you cannot directly link the victim. And if you want to talk about direct linkage here, if you look at the cross-examination of defense counsel of the expert, which is on I think it's the third volume of the transcript, page 69 through 71, defense counsel actually took the medical report that was introduced to the jury, I believe it was Exhibit 1, and she went through with Dr. Forkey and said, you know, didn't you discuss the didn't you discuss behavioral characteristics of sex abuse victims? She said yes, and she went through a series of those characteristics. You know, depression, anxiety, bedwetting, changes in appetite, difficulty in school. And she asked, you know, and those are common characteristics of sex abuse victims? Dr. Forkey said yes. And then defense counsel went forward to say, and isn't it true that the victim did not have difficulty in school, did not have depression, did not have anxiety? So if you want to talk about direct linkage, it was the defense counsel in this case that actually tried to directly link the victim to sex abuse victims in general. And she did it in a way that actually strengthened the defendant's case. So not only could the defendant argue that there were no physical symptoms here, the defendant was also able to argue that this victim did not display any of the behavioral characteristics associated with child abuse victims.
We can turn to the closing argument. Here's my concern. There's only one instance in which she describes ejaculation, which is, I think, the first. And the statement that is given by the ADA regarding what the mother said is directly corroborative of the existence of ejaculation. Because why else would she need a bath? How is that not prejudicial, given the particular nature of this statement?
Certainly, you know, this was a misstatement, but I believe it was a good faith mistake on the part.
Let's put aside.
Okay.
We can assume that.
Okay.
We will assume, for the sake of argument, that it was said during the course of the interview.
Yep.
But that's, as you point out, neither here nor there. But we're certainly not going to infer that it was done malevolently. The problem, it was not in evidence. So what do we do with the issue of prejudice?
Well, I think it's different I think you have to consider that the victim also testified about that incident, that the victim talked about how she had that conversation with her mother, how she went back home and said that she wanted to take a shower despite her having taken a shower an hour before. And you had the victim testify that after that first sexual assault, she felt wet, sticky, and disgusting. So the jury had the reference to that through the victim's testimony. And it's not as prejudicial because of what was discussed earlier, that there were other forms of corroboration. And I just want to suggest that those other forms of corroboration really can't be assigned any innocent explanations. The victim did not ask her mother that she didn't want the defendant to be picked up anymore because she didn't like coming home late. She asked her mother that. The jury could have reasonably inferred that she asked her mother that because she did not want to get digitally raped in a Burger King parking lot anymore. When she told her mother that she asked to come home early on New Year's Eve, it wasn't, as the defendant suggests, because she didn't like sleeping over other people's houses. The jury could have reasonably inferred that she wanted to come home, and actually the victim testified that she didn't want to come home because she didn't want another incident of sexual abuse to occur again, and the victim specifically said that. She testified that the defendant attempted to sexually assault her every single time that she stayed over the house. He was only successful on that one time, the month before New Year's Eve, but there was an attempt every single time. So really, you really can't assign an innocent explanation to the other corroborative testimony. So because of the other corroborative testimony, Your Honor, I don't think there's as much prejudice as the defendant suggests. Excuse me.
Bowden question?
Sure.
I have to tell you, every time there was a Bowden defense, when I got to the final instructions about you not to engage in any guesswork or speculation about any unanswered questions you had, I would get this churning in my stomach about how can I reconcile no instruction on Bowden and yet that instruction, which we have in probably every case. Mm-hmm. So does that instruction eat into the effectiveness of the Bowden defense when there's no Bowden instruction?
I don't think so, especially in this case, Your Honor, where the majority of the cross-examination of Detective Brissett, who was the investigating officer, talked about the fact that there weren't a lot of other witnesses interviewed. And I think the prosecutor made clear, and I think the record indicates there weren't any other witnesses to be interviewed because all of these acts occurred in private. No one else was going to provide any other testimony about these incidents.
All right, let's step out of this case for a moment.
Yeah.
Do you think it's difficult to reconcile a Bowden closing with that instruction?
I think that the case law makes clear that as long as a judge allows a defendant to pursue that type of questioning during a cross-examination, and as long as they're allowed to argue that in the closing argument, which this defendant certainly was, I don't think the lack of a Bowden instruction made, as large as an impact as the defendant makes.
I understand. That's not my question.
Okay.
My question is much more general.
Okay.
So the defense attorney has just made an impassioned Bowden defense closing. The judge, within his or her discretion, doesn't give a Bowden instruction. And then the judge goes to the beginning of the general instructions before getting to the elements and tells them, now don't engage in any guesswork or any speculation about any unanswered questions that you may have. And I'm asking you whether or not it's hard to reconcile that instruction with the Bowden defense that was just argued.
Well, I guess I would argue that there wouldn't be as much guesswork necessarily involved when like you had here, or maybe a similar situation where there was a question about an alleged flawed investigation, not enough witnesses were interviewed, and there is an explanation. They weren't going to rely just on guesswork. They were going to rely on other things that there was no need for. Maybe I'm getting away from your question. There was no need for there was an explanation as to why the investigation was allegedly flawed. And I think there is not as much guesswork in these situations as that instruction may imply.
How do you distinguish the Derek Smith case, Commonwealth versus Derek Smith, where the appeals court decides that, again, it's a missing witness context, but it's the same speculation language and decided it is prejudicial error?
I think I don't think there's as much comparison between a missing witness situation and this situation. There's no way the defendant can argue that there was an additional witness that could have been interviewed or that could have testified at trial. All these acts occurred in private. So I think it's a very different matter.
It's a different point. They're reasoning by analogy from the missing witness. Your brother says, look, in the missing witness, when you don't give a missing witness instruction and then you put in this do not speculate or guess, that creates error. And the appeals court agreed.
But I guess I would say the jury could still rely on the testimony and still rely on the argument that the defendant made. It's not just, it wouldn't be a hypothetical situation.
Okay.
And if there are no further questions, the Commonwealth will rest on its brief. Thank you very much.
All right, now we shall move to the stay in a moment.